Hello everyone, I am Rosalind Croucher and I am President of the Australian Human Rights Commission. And on behalf of myself and the Commission and the Australian Human Rights Institute, I'd like to welcome every one of you to today's event. Today we are reflecting on the first 10 years of the United Nations Guiding Principles on Business and Human Rights in Australia, and launching our joint report on this topic. I'm speaking today from Sydney, so I want to start by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of these lands, and I would also like to recognise and pay my respects to elders past and present, and to the emerging leaders of the lands on which you all are today, and extend those respects to any First Nations people who are joining in our important discussion today. As many of you joining us would know, the UN Guiding Principles on Business and Human Rights, the so-called UNGPs, were unanimously adopted by the United Nations Human Rights Council in 2011 and are the current authoritative global standard for government and business on preventing and addressing business-related human rights harms. The Australian government co-sponsored the resolution at the United Nations to adopt the UNGPs. Sadly, however, last week, the architect of these wonderful guiding principles, Professor John Ruggie, passed away. This is a great loss for the business and human rights community globally, and I know Justine will have more to say on this sad topic. 2021 marks the 10th anniversary of the introduction of the UNGPs. The Commission has partnered with the Australian Human Rights Institute of the University of New South Wales to release a joint report on the implementation of the UNGPs in Australia during their first decade. The report is available now. It's live on both the Commission and the University of New South Wales Australian Human Rights Institute's websites, and a link to the report will be put up later, but it is live now. I'm shortly going to introduce Professor Justine Nolan, who is Director of the Australian Human Rights Institute and the co-author on this important report. Justine will provide us with reflections on the report, and then we'll moderate a panel discussion with a fabulous group on the report and the UNGPs in Australia. But first, what will you find in our report? The report is a stocktake of sorts and considers the progress that has been made in Australia over the last decade in the implementation of the UNGPs by business, by investors, and by the government. As many of you appreciate keenly, the focus of the UN Guiding Principles is preventing risk of harm to people connected with business activities. The expectations outlined in the UNGPs are increasingly incorporated into a wide range of laws, policies, standards, and business practice around the globe. In the report, we consider a broad range of business and human rights areas, in particular, combating modern slavery, embedding human rights due diligence into business practice, respecting the land rights of Aboriginal and Torres Strait Islander people, addressing the adverse human rights impacts of climate change, leveraging the role of institutional investors, and ensuring access to remedy for victims. The report points to some key areas of progress, including the introduction of the Commonwealth Modern Slavery Act in 2018, and the establishment of an OECD national contact point. The report also identifies gaps and areas of future focus. However, ultimately, the report concludes that much work remains to be done to address significant gaps in corporate accountability for adverse human rights impacts, to ensure victims have access to remedy, and to operationalise the business responsibility to respect human rights in Australia. The report has laid out a call to action for government, for business, and for investors, with a set of recommendations for further implementing the UNGPs in a more substantive manner. The report is short, but it covers a lot of ground. We hope it can serve as an advocacy tool for the diverse range of actors working to embed respect for human rights in Australian business practice, including in civil society, business, investment sector, and in government. It is crucial that our work at the Human Rights Commission is informed by experts, which is where our opportunity to partner with the Institute on this piece of work has been so invaluable. The report draws on insights from key Australian stakeholders, from business, investors, civil society, unions, and academia. And I want to say a big thank you to those stakeholders who were very generous, as always, with their time and expertise. The sector-specific insight that you provided was of enormous assistance to us. I'm sorry that we were unable to host this launch in person, in 3D, as I've come to say, as we know that such events allow for an informal knowledge sharing and meeting of minds across sectors that can generate so much space for progress. But today we're in 2D. And for those working on business and human rights issues, it is a ready reminder of what we know are the additional challenges that the ongoing COVID-19 pandemic poses for vulnerable people in these spaces and the urgent need for further action to be taken. And just before I hand over to Justine, I would also like to acknowledge some key staff within my own commission who were involved in this report. Sarah McGrath, Lauren Zanetti, and Kate Griffiths. Thank you to those three in particular. And now it's over to Professor Justine Nolan, who co-authored the report and who will be moderating today's panel discussion. Justine is a professor in the Faculty of Law and Justice at the University of New South Wales and director of the Australian Human Rights Institute. As many of you know, Justine is also a leader in the field with over 20 years of experience in the business and human rights arena. Justine will provide her reflections on the report and its recommendations, and then introduce and moderate our wonderful panel. So from me, it's a big thank you. And now over to you, Justine.
Thank you so much, Ros, and thanks everybody for joining us today. I just want to reiterate the thanks that Ros mentioned for my co-authors, Lauren Zanetti and Sarah McGrath, and also the support of Kate from the Human Rights Commission and Drew Sheldrick, the Communications Manager at the Institute, for bringing this report together. As Ros mentioned, this is a really apt time to be discussing progress on business and human rights in Australia, not only because it's the 10-year anniversary of the establishment of the UN Guiding Principles, but also because it was just last week that news filtered out that the architect of the UN Guiding Principles, Professor John Ruggie, sadly died. And he has had, just an enormous impact on this field with the development of these principles and changing the way people think around the integration of business and human rights. One of our panelists, who I'll introduce shortly, Rachel Davis, has worked very closely with John, particularly more than the last decade, but also on the development of these principles. When I first met John back in 1999, I was a junior lawyer working for an international human rights organisation, and he met with me and my then boss, Professor Michael Posner. And I remember we met in the canteen of the United Nations in New York, and he was pitching to us the idea about establishing something that he was calling a compact, between business and the United Nations, and how it would change the way people started to think. Full of myself as only a junior lawyer can be, I was very hesitant about the idea. I had some misgivings, and he essentially said to him, come back to us when you've got something better. And when our paths next crossed and he was in the process of establishing the UNGPs and sort of dealing with the international consensus around this, I remember one meeting much later, he said to me, so what do you think, Justine? Is this a better idea? And I gave him credit for this one as we went on. And that was very much how John went about his work in terms of consulting with people, traveling the world to try and get these principles developed. And they were a turning point because they started to build more consensus and mainstream the idea around business and human rights. So the idea of this report was to sort of do a stock take, as Ros said, and sort of, well, we're looking at Australia in particular, where have we got in the last decade? What steps have we taken forward? And where have we still got to make progress in relation to this? We did, as Ros mentioned, pick these 6 particular issues to focus on around modern slavery, human rights due diligence, the land rights of Aboriginal and Torres Strait Islander peoples, climate change, the role of institutional investors, and looking at remedy for victims, as we felt that these were particular priority areas in Australia. As you would know, we could have taken into account any number of business and human rights issues, but we were trying to make a sort of a short, digestible, and ultimately actionable report that would perhaps come to the attention of both business and government in relation to this. So where do we end up in terms of our conclusions on this report? Well, as Ross noted, overall, we recognise that there has been significant progress in Australia, but overall our assessment is that perhaps in the last decade, the approach to date has been somewhat ad hoc and lacked cohesion in creating an enabling environment for rights-respecting business practices in Australia. For many Australian businesses, including institutional investors, there still remains a voluntary sort of corporate social responsibility mindset that remains prevalent, and awareness of the guiding principles in the business sector is still fairly low. Corporate responses to the Modern Slavery Act, which has been a step forward by Australian government in the last couple of years, do range from sort of rigorous to superficial. And the acceptance and an understanding of the need to embed human rights due diligence in these practices remains limited. Remedy remains rare for many victims of business and human rights related abuses, particularly, but not limited to those that experience harms overseas that are connected with Australian companies. There's also a disconnect in Australia and elsewhere between the United Nations Guiding Principles and some of the key issues discussed in this report, such as climate change related human right related harms and land justice for Australia's First Nations people. So before handing to the panel in just a moment, I just want to sort of pick out just a couple of our recommendations that we have got in the report to business, investors and the government about next steps that we need to take to substantially implement the guiding principles in Australia. We are thankful, as Ros mentioned, for the background interviews we had with a number of stakeholders that provided us some guidance around the issues that they see as important and their take on where we should go, where we should move forward in relation to this. So to Australian businesses, some of our recommendations are that we recommend that you start to invest more heavily in building human rights knowledge and capacity within your business and actively consult with external experts and rights holders. This can often be a sort of an unusual thing that business is not used to, actively reaching out to workers, worker representatives, trade unions, civil society, in order to increase expertise around this issue. And we're arguing that consultation must not be done in a tick-the-box approach, but must be very substantive. We're also asking you to actively engage and understand the concept of human rights due diligence that is emerging, most prominently, most recently in Europe, but also globally, and understand that it requires both proactive and reactive elements, including preventing and remedying wrongs. And recognising that issues such as climate change is one of the most urgent human rights issues that we are now facing, and that you have a significant role in addressing it. To Australian institutional investors, we are asking you to use your leverage to require the companies you're assessing that they conduct human rights due diligence, help them understand what this means, and work towards common guiding principles aligned social, environmental and governance methodologies, that there is a common benchmark and metrics that companies can understand in relation to this. The Australian government, some of the recommendations we are pushing in this report include strengthening the enforcement framework of the Modern Slavery Act, legislating for mandatory human rights due diligence, providing a legislative and policy framework that will enable victims of human rights abuses to seek remedy, and meaningfully incorporating the principle of free, prior and informed consent into the Native Title Act. So as we say in this report, Australia is now at a crossroads, and there's both an immediate urgency and opportunity to substantively implement the guiding principles in Australia, and we hope this discussion today and our report will start to advance that. So let me begin by introducing the panel. And the idea is that we'll have a discussion with the panelist, and we really encourage your interaction in this discussion. So please feel free to enter comments and questions into the chat, and we'll have time at the end of this session for the panelists to respond to some of your questions. So today with us, we're fortunate to have 4 great speakers. We have Luke Fletcher, who's the Executive Director of Jubilee Australia and a visiting fellow at UNSW School of Social Sciences. Rachel Davis, who's the Vice President and co-founder of the Shift Project. Phoebe Wynne-Pope, who's the Head of Business and Human Rights at Cause Chambers Westgarth. And Ro Coronius, who's the Senior Manager of Risk Supply Chain at Lend-Lease Corporation. So let me start, Ro, and by throwing it to you with the first question. And let's pick up on the theme of modern slavery, which is one of the themes of the report. Reflecting on your experience and the reporting that you've done, particularly over the last year, what would you say has been the impact of this Act on Australian business landscape more generally, and also specifically, how has it impacted the particular work that you are doing?
Yes, thank you, Justine, and hello, everyone. Look, I think there's 5 key sort of reflections I have on this. The first is that, yes, the Act is precipitating awareness and shaping new norms for elevating the importance of screening supply chain risks for larger corporations. It's made the issue unavoidable to address. You know, if you're making it a compliance requirement, like it or not, businesses need to look at it. But I must say that we are still on the learning curve and certainly an early stage of maturity in reporting. And I think we need to distinguish between reporting disclosure and the actual work that needs to be done to effect that change and improve the transparency into our supply chains. So, and I mean, in terms of the Lend-Lease experience, we've been, if you like, over the last 18 months to 2 years in foundational stages of implementing a range of things, from awareness and education and reinforcing that awareness, not only within our business at different levels, and there's different sort of nuances in the messaging around that, but also the variety of suppliers in our supply chain. It's about establishing policy systems and processes and integrating and embedding. And there's a whole raft of change management that needs to go along with that. And that's, you know, that's actually the hard yards from our experience. That's the real work. There's methodologies, you know, reframing traditional approaches like the concept of a social audit, looking at what's in the basket, if you like, for third-party risk intelligence screens, and even some real constraints over the last 18 months with COVID and geopolitical changes can actually create some additional complexity and asymmetry of information when you're trying to get into the supply chain. Then there's the actual situation, you know, of finding and looking and tiering, if you like, or prioritising the risks. What sort of guidance around materiality do we need? You know, the supply chain systems are dynamic, but there's also resourcing requirements to check on things, to check on your suppliers. And how do we have response mechanisms when we find it? What's a good practice consequence management framework? And, you know, we're still never always going to have perfect symmetry of information in the deeper layers of our supply chains. But it will also, I mean, I think the Act is also triggering other broader strategic questions around, you know, the concepts of concentration risk and disciplining, you know, the breadth of your suppliers and looking at what risk is in your supply chain in a more holistic sense. And then you're capturing data, of course. So what do you do with that data? The education that's needed to move beyond input-output measures to proof points of effectiveness, and what's an appropriate indicator framework for determining effectiveness? Should this be standardised, for example? And maybe there could even be, I suppose, a suite, a sort of small core suite of indicators that can enable measurement on progress with some degree of comparability across the corporate sector. The other thing too is, converging with other regulatory reforms. Corporate criminal liability, anti-bribery and corruption, that's all evolving, and there are intersections occurring there with modern slavery risk. The other thing too is we need more exemplars, of good practice. Businesses need to be courageous, and now I think that's a cultural thing, in presenting case studies of where they have found modern slavery or a form of modern slavery, and then framing these as a positive impact from their efforts, not a shameful thing to brand or management. We are also in the early stages of consortia approaches to tackling high-risk supply chain categories, and I'm all for doing more of this, because I think that's a really effective use of our resources and time if we can tackle this issue collectively as an industry and also jointly with our suppliers. I think also technology will have a role in the future around materials tracking, so track and trace, extending functionality to more than just locational or inventory management, but more sophisticated approaches around sort of looking at how your products are made and where they come from. And I think the final thing that's really important at the heart of all this is building awareness around a victim-centred approach. And that's about us better engaging with NGOs, not being afraid to engage with NGOs on this issue, who have the expertise and the coalface, and looking and actually building that understanding across industry around what a victim-centred approach actually means.
Yeah, so you've highlighted some issues that if we think about 10 years ago, would we have been having discussion with business when they're talking about a victim-centred approach, a people-centred approach, and these are the types of things they're grappling with? That really wasn't happening very, very often 10 years ago when we were having discussions with business. So Phoebe, in your role at Cause, you're advising companies on some of these issues, and Ro has outlined, a lot of the issues that companies are grappling with, and particularly a lot of focus that they've had to come up to speed with just in the last year about looking at policies and then how you actually translate those, into practice. And many companies are more at the grappling with policy stage. But in your advisory role there, how have you seen the impact on businesses? But also, there's been a lot of critiques about the Act itself, and with the review slated for 2022, with the government undertaking to reassess its effectiveness or look at how the Act is operating, do you think it needs to be strengthened in relation to that? Thanks, Phoebe.
Thanks, Justine. I think there's a whole range of issues to unpack in that question, and the short answer to whether the Act probably needs strengthening, I think the answer is most likely yes. But we're also aware that we're all on a big learning curve. So what we see a lot is organisations like Rose that are really taking this seriously and diving into their supply chains, and they're really looking at their operations and the impacts that they're having, and they're considering those in a meaningful way, and taking a very much of a rights-based approach. And then we do see other organisations that are more inclined to just see it as a reporting requirement alone, and what's the bare minimum that they need to do just to get across the line. So we see a huge range of things. I think there's a few issues around the UN guiding principles that I just wanted to draw out, because I think even with those who are engaged, there's often a hesitancy to take on expert advice around the application of the principles and around the human rights risks in their supply chains and operations. And where the guidance to the Act really leaned heavily on the UN guiding principles, which was fantastic, I think that what we see is that the Act has brought about a very narrow focus on modern slavery, and a lot of organisations aren't really looking left and right at other human rights impacts that they might be having along the way. And I think it's a really missed opportunity. If you're putting in place these due diligence processes for modern slavery, should be also looking at the other sort of risks and harms that might be occurring up and down the supply chain. So I think that that's one lost opportunity. We also see quite a lot of organisations putting out policies and practices that reflect in and of themselves a little bit of a lack of understanding of human rights. So I can't remember how many policies I've counted that says something like, we respect the fundamental principles of human rights found in the Universal Declaration of Human Rights and in the UN Guiding Principles on Business and Human Rights. And just a clear lack of understanding that the guiding principles are the most, wonderful and authoritative tool for the application and practical guidance on how businesses should be respecting human rights, but that they don't actually have the human rights standards in them themselves. And to me, that, there's a real opportunity, and I think your report brings it out, this need for education about human rights, not only about the guiding principles and the application of them, but actually what are we talking about when we're talking about human rights, and what does that look like? I think this is often covered off in, a range of different faculties across different universities, but needs to also be incorporated into commerce degrees and into MBAs, so that when people are thinking about basic functions of good management, they're thinking about their human rights impacts up and down the value chain. I think the other thing that Ro raised was this issue of distinguishing between the reporting and the work done, and that need for the victim-centred approach, that do no harm, which approach to really have a genuine impact. I think that we're still a little bit away from that being a common approach. I think the do no harm to people is often misinterpreted as a do no harm to the business, and how that extends to a sense that we shouldn't be putting in place programs that require, resources unless we absolutely have to, and that have to reason might be for a variety of reasons. It might be a mandatory requirement like the reporting, or reputational risk, or attracting investment through ESG funds or whatever, but a greater sense of that obligation and that requirement in the UNGPs to do no harm, I think is part of that educational process.
Yes, so I might pick up on that and sort of ask Rachel to expand a little bit on that. Thank you for those comments, because I think you pick up some of the discrepancies that Ro raised in terms of moving from principles into practice. And, Rachel, I always complain that I've been on more calls and conversations with companies than I would like when they tell me about their human rights journey. And you would have been on many more in relation to that with your work at Shift. But what we've seen over the last decade and more recently has been this focus on this emerging concept of human rights due diligence, which is trying to take sort of the problem that Phoebe identified about a narrow focus on modern slavery to a more, a larger concept on human rights, and embed that into business. And particularly we're seeing the issue coming in Europe, and so we'll be interested to hear a little bit about how it's emerging. But one of the questions we've already had on the chat is from someone who said, what can be done to prevent abuses by businesses such as the destruction of Yukon Gorge by Rio Tinto. And so, it would be useful to think about, when you think about this concept of human rights due diligence, as you tell us where it's going, how it might apply or be relevant to perhaps a situation like that as well. Thanks, Rachel.
Thanks very much, Justine. And thanks also to you and to Ros for your comments about John, who was indeed a dear friend and a colleague for many years, as I know he was also for others joining today too. I think the place I'd like to start in answering those questions is that the guiding principles are not actually a fully voluntary standard for states. They specify action that is expected of governments as part of their existing human rights duties, and that includes proactively looking at whether current laws and policies adequately protect against business-related harms to people, and where there is evidence that they don't, then addressing that. And I think the example that you just cited is a good example of where our current laws are not adequate, and that's clearly stated in your report. But to turn to what's going on in Europe, I mean, we see a growing number now of European governments clearly deciding that their current laws do not offer sufficient protection. In Germany, in France, in the Netherlands, to some extent in Norway, Switzerland, and now, of course, a debate at EU level. And the requirements of these new laws that are being adopted or debated very clearly reflect key elements of the guiding principles. They include reporting, but as one element of comprehensive due diligence, and as has been said, the sort of doing the full work that needs to lie behind disclosure. And I think it's important that we are seeing growing business support for EU-level regulation. That's really coming from a desire and a concern amongst European and US companies for a level playing field, and wanting the EU to step in that regard. And certainly some businesses are concerned. There's a lot of details to work out. But when you start to see leading companies like Ericsson, Pepsi, H&M, Unilever, Nestle, ABN AMRO across key sectors, pharma, food and beverage, consumer products, even finance, apparel, coming out in support of robust EU legislation, then we can see that something is shifting in this debate. And the German and the Dutch laws in particular were based on national action plans that required a comprehensive assessment of whether voluntary uptake by business was enough, whether it was having the intended effect. And those assessments over the last few years showed that it was not sufficient. So what we're seeing here are evidence-based decisions to move towards more comprehensive regimes. And I think that, in my view, our government here is yet to have that frank policy discussion about what's needed beyond the Modern Slavery Act. And your report makes an important contribution by calling for that. The report also makes a really important point that in moving towards any kind of comprehensive regime, clearly defining the due diligence standard and the thinking about the approach to enforcement will be really important. And we're working on both these issues at Shift in the European context right now. And on the first, on defining the standard, just a brief point on each. It's really essential to get what differentiates human rights due diligence right, as Phoebe was saying, and that has to prioritise engagement with affected stakeholders. That's a very still difficult and weak area of practice. And it also has to touch and connect with strategic decision-making in the business. If your business model is connected to severe risks to people, that's a top-level discussion. It's not something that a junior manager with a limited amount of resources and sway can realistically address. And we're starting to see that recognition of the governance implications of this come through in the European conversation. When it comes to the second point that you touch on, enforcement, again, I think it's very important that there are important aspects of due diligence, like not cutting and running when you find a problem, and also disclosing significant risks where you find them. And as Ro was saying, we want to make sure that any new regimes, existing or new regimes, encourage this kind of disclosure by business, encourage engagement with problematic business partners as part of moving to better outcomes for people that the guiding principles envisaged and really want to see happen in practice.
Thanks, Rachel. And there's lots of questions coming through, which I'm thankful for, so keep putting them into the chat and we'll go to them in just a minute. But I first just want to bring Luke into the conversation. The third pillar of the UN Guiding Principles is focused on remedy, and it's long been recognised that in the last decade this has been the most underutilised and not implemented as well and not understood as well as the first two pillars in relation to it. So, I'm interested in your work at Jubilee, Luke, which is often, very particularly focused on working with survivors and communities who are at risk from corporate human rights abuses. How do you think that is the most effective way, perhaps, that you're advocating for remedy, or this concept that's coming in the guiding principles, how has it become relevant over the last decade?
Thanks, Justine. I think it's important to sort of to remember where we are, where we're located geographically, and where our businesses, the Australian-hosted businesses, can have the most impact. We're sitting in the edge of the Pacific, right next to or part of a region which has a wealth of natural resources that are potentially monetizable. right? And what because our work is largely focused on the Pacific, that's something that's very we have to be very cognizant of when we look at where the harms are being perpetrated against communities. So I think it's important to say, and also I think it's also important to sort of we've talked a lot about modern slavery, and that the sector is obviously important when it comes to protection of workers, but there's also the issue of the protection of communities and people who are often very much vulnerable to sectors such as, I mean, we may as well just name them: mining and extractives, oil and gas, logging, agribusiness, fisheries. These are the sectors, particularly in our region, where there's a temptation by corporate actors to plunder resources and impact, therefore, the human rights of people. Right. So the issue with remedy comes in, Justine, when we think about the fact that if there is no clear, strong regime for recourse to remedy for communities that are affected by these harms, it emboldens the most reckless type of actors, and that's what we see in our work. Rachel was mentioning the importance of business. Touched on the idea of business models. Unfortunately, there are some companies whose very business models are inconsistent, we would argue, with environmental protection and human rights, and that's where remedy is important, because without sanctioning these companies, their business models will be emboldened, and investors will be tempted to support them. So I think that's important. In terms of the report itself, I just wanted to say that the findings of the report that we're talking about today are absolutely spot on. I think it's identified that there are huge gaps when it comes to extraterritorial harms in terms of looking at the behaviour of companies that have actions overseas. The report highlights the barriers to litigations. And Human Rights Law Centre, shout out to them. They've done a lot of good work on those barriers as well in the previous years. The courts in other industrialized companies, as again the report also notes, are beginning to take on cases of parent companies acting in the home states, and Australia is behind in that. So there's a gap in that regime, right? It strongly endorsed the call, therefore, in the report for a statutory civil cause of action for serious human rights harms in Australia. So that's a really important, I think, recommendation in today's report. So yeah, just really want to say that we've certainly noticed that in our work, that there's a real gap there. I think you wanted me to touch briefly on the Australian National Contact Point, so I'll just say a few quick things about that. Firstly, we obviously have seen some strengthening of the Australian National Contact Point, both in terms of its governance and in terms of its willingness to sort of, I think, take on and really wrestle with cases that are brought before it in the past couple of years. I think that strengthening of the Australian National Contact Point has seen civil society really encouraged to bring more cases before it. And I think that's a really positive thing. And it's also seen some encouraging findings. I think the ANZ Phnom Penh sugar case that was brought forward by Oxfam and other partners was a really helpful resolution, and showed the value of it. I think the ongoing case that Human Rights Law Centre have been involved in with the Rio Tinto and the Bougainville Panguna cleanup question, which we've been supporting as well, is showing promise. But I think there are still question marks about the Australian National Contact Point. We've yet to see evidence yet that it has the capacity to deal with complaints due to that deal with the problem of free, prior, and informed consent. So that's where we're trying to, in a sense, almost prevent remedy by bringing cases towards regulators where we can see there's going to be harms and stop them from happening before the harm's happening. And I guess that's not technically remedy, but I think it is really a part of the remedy regime, because obviously you want to prevent harms before they happen, and regulators are important there. And a final comment on the National Contact Point. I think the proof is going to be in the pudding in terms of how it deals with the larger number of complaints that are brought before us in the coming 12 24 months, and so we're really looking forward. We're really looking carefully at that. If I think I'd end on a final thought, which is that if the ANCP is not able to deal with and assist communities with remedies sufficiently, then we will have to look at other options. But obviously, it would be better if the ANCP regime can be strengthened to really work for communities.
Thanks so much for those comments, Luke. And I think what the report's trying to draw out there around remedy is saying that we've got some of the beginnings of where it can go, but we need to have more follow through from both business and governments and engagement by civil society to strengthen this. And one of the areas, two of the areas we pick up too around land justice and also climate, but other issues as well, and workers in global supply chains. So I want to bring the whole panel back because there's some questions that have come through from the audience. And one to start to you, Ro, is directed to you. It says, do you think human rights language is something Lendlease and other Australian businesses are comfortable and engaged with? To Phoebe's point, beyond the Modern Slavery Act, where else or how else does Lendlease think about these issues in terms of its business operations?
Yes, look, I think the language of human rights is an interesting one because I think there's a lot of education that needs to occur. If we take the ideology, if you like, of what the human rights, the UN guiding principles, it's fantastic. But how do I ground that in a very practical sense? I have to communicate that to a cohort of people who have a preconceived view of what they think human rights might involve. And in some respects, it can seem quite daunting. This is a complex area. We could be opening up a can of worms. That sort of demeanour we get. So the discourse around human rights needs some translation in a practical sense. We do observe it, but again, it's this thing about how do you show that in a very practical way, and I think we're at the very early stages of that.
And so on that point, Rachel, because another question beyond human rights language is also about how do this concept around human rights due diligence, for example, how do either companies or perhaps not-for-profits actually do it if they're in a resource, sort of limited way? So a lot of attention is often focused on the really large global companies who will have a dedicated at least one sustainability person, often a small team. But there are companies who have no such person and non-for-profits who have no such person. So how do we develop that education, but also the ability to think about concepts like human rights due diligence and apply them in those areas?
It's a great question. I think, there are an increasing number of resources available now, but one of the things we've seen firsthand through our work at Shift in engaging with SMEs in particular is that, first of all, the list of issues that may need to be tackled may be relatively narrower, but it may be easier to work on some of them because where these do connect to as I was saying before, fundamental decisions that need to sit at the strategic level of a company, that gap is much narrower in an SME context, and the connection to core values of the business may be easier to make. So in some ways, there may be an advantage for smaller organisations, but I think we're starting to see already the result of the movement in Europe that I was talking about. I mean, Germany is primarily an SME-based economy. Many economies are. And there's going to be really a growing number of publicly available resources, and importantly, resources being provided by governments, because that, I think, has been lacking till now. There have maybe been private resources available in the market, but we want to see, I think, more authoritative guidance and support from states to equip a greater number of businesses to provide this, and I think that's happening now.
So a follow-on question from that is coming from Simon that I might start with Phoebe and then bounce back to you as well, is that given the elevated level of engagement we're seeing in places like the EU and potentially their sort of approach of human rights conditionality in both trade agreements and other mechanisms, in Australia we've recently seen an attempt by Senator Patrick to develop a forced labour bill which is focused on using sort of import bans in relation to it, which might supplement something like the Modern Slavery Act, but that was not successful and wasn't supported by the government. So Phoebe, to what extent do you see sort of this room to have, other approaches working together, Is it needed? Is it excess? Do you think that the government's right to perhaps wait and see on these approaches? What are the next steps around this area of making in strengthening enforcement?
Well, I think we always talk about that ideal mix of the voluntary and the mandatory. I expect that we're not really there yet because we're not necessarily seeing enough engagement. I think there's a couple of issues. One is we know that what happens overseas comes to Australia. So, you know, the UK Modern Slavery Act might have come in 3 years before ours, but if Europe and other parts of the world are moving towards mandatory human rights due diligence, I think that we can expect that that will happen in Australia as well. And companies that are thinking about that now and getting ahead of the curve will do well for themselves. I think the other aspect that I was going to touch on is this issue around how you go about doing that and the extent and the difficulty that some of our clients are seeing, and I think lots of businesses are seeing, where they know that the risks of modern slavery or other human rights harms are deep in their supply chain, and their contractual reach and access to those individuals affected is really complex and difficult, if not impossible. And trying to build a much greater understanding amongst organisations about how they can actually address some of those harms that are further away in their supply chains will be really critical to keeping business engaged and keeping business thinking that actually that they can have an impact. Because, you know, if you get to the stage where you actually can't reach the people that you know are there and possibly in harm and really struggling. And I think that the engagement with not-for-profit sector and with a whole range of other stakeholders will become really key in that. But that also requires a lot of trust between different sectors and access. And it's really hard. I think that we have to acknowledge how hard that is when we know it's there.
So, Rachel, when do you think realistically, you've been involved in these EU discussions, that we might see something coming from the EU in relation to these concepts around due diligence?
That is the million-dollar question that no one seems to have the answer to. And I think what we're seeing at the EU now is a series of parallel conversations starting to converge. So there's reform of reporting, there's the potential for comprehensive due diligence laws, as I was flagging, and there's now been an announcement, of course, by the European Commission President that the EU will move towards this model of adopting import restrictions on goods made with serious abuses like forced labour. And I think and there's some commitment to move these conversations forward at the same time. The current timeline is December for a proposal on a number of interrelated initiatives, but it will take potentially a couple of years for all of this to be negotiated and implemented. But we see companies already moving to prepare for this as a reality. And as I said, it's a reality in some national contexts already. Just on the import question, I think if we're going to consider that kind of an approach in Australia, then we have to learn from what's happened in the US and say, how do we do this in a way that doesn't just lead to further negative impacts on workers, workers losing their jobs because the goods were produced in poor conditions and have now been blocked? How do we actually get to remedy for the people who have been harmed? That's a really important lesson that I know you and others are very aware of. And how do we ensure also that we're applying this equally to all goods and imports, that we're actually concerned with the same set of harms, and it's not just becoming a political tool. There's a real risk of that in our current context. We see that in the US experience as well, and it will be very, very important to avoid that. And hopefully the EU discussion will take some of those sensitivities into account.
So, Luke, when you hear this sort of discussion around the movement that's happening, and, you know, in international human rights, incremental movement is the sort of the cornerstone of how the system works. But in business and human rights, it's actually been relatively quick if you look at sort of human rights more generally. But still, to get these types of legislative changes is time. The impact of things like the Modern Slavery Act will take time to filter down if it's ever going to reach the bottom of supply chains. You know, what else should companies be thinking about now in terms of both prevention and remedying, you know, from the communities that you work with?
That's a
in,
very
you
good
know,
question.
2 minutes or less.
Yeah, I think that's a really good question, Justine. I think that it's already been touched on earlier in the call about engaging with civil society when these issues arise, rather than being a defensive posture, which is just unfortunately I have to confess, and this is partly because, as I mentioned earlier, the sectors we're working in, where the business models are problematic, unfortunately, the inclination is often just to reject outright any approaches to companies. We always approach companies first before we, quietly and privately when issues come up, and we try. Obviously, it's much easier to resolve them bilaterally, just by sorting it out without having to use these processes or going to the public or going to the media and that sort of thing. So I think my main thing is to be open to hearing what communities are saying. But I also do, I would also say that I think, and this applies to investors as well as companies, is that we have to be real, about what's happening in the world. We're seeing mass extinction. We're seeing the greatest threat. We haven't touched on the climate issues in the report. We're seeing the greatest human rights and environmental threat for millennia in terms of climate change. And I think companies have to get real about their business model. If their business model is extractive and exploitative, killing species, causing climate change, then they have to get real about that. So that's probably not what some people want to hear, but it's the truth.
Yeah, so going from that the hard truth row to you around those connections between climate and business that 10 years ago were not the norm, and neither were human rights norm discussions within the company. To what extent are those discussions elevated now alongside, integrated with human rights or siloed from it? How are you approaching that?
I think.
Sorry.
Oh, sorry.
Go ahead.
Oh, sorry. Was that a question to me or to?
Yeah, you go, and then I'll come back to Luke.
Okay, sorry. Yes, look, I think the social and environmental dimensions have been running in what I would call parallel universes. I think there's a notional understanding, but it has taken some really terrible and tragic events to really bring this home. So it's almost played out in front of us like a disaster movie. 2019 bushfires, we've got catastrophic impacts to biodiversity. We have, drought, flood, plague, pandemic, even earthquake yesterday. And it's like the universe is saying, guys, what's it going to take for you to realise that we have to change now? And I think COVID-19's accelerated the sense of alarm and vulnerability and realisation that our institutional structures, our business models, not only are not bulletproof, are not sustainable in the long term. And I think if we had social strategists and environmental scientists swap lenses for a day so that each could see the other perspective and draw those connections together, I think that would help to take a more holistic view, that you don't look at the environmental, because that's been an extremely complex, kind of discourse in itself. And, even for people in finance to broaden their purview of what is being added to that risk basket, if you like, and recognising that the direct and indirect financial costs and the chain of causation that leads to that harm, consider what are also those things that avoid or mitigate that harm, which is a kind of more economic cost-benefit analysis approach. But I think also decision makers, at the, executive level, there's always been this notion of a duty of care under the Corporations Act, and the business context has impacted the way it's interpreted over time. But I don't think anymore it's a question of, whether those duties extend to climate-related risks. I think it's now, well, what are you going to do? And if, for those who may have had a chance to read the Noel Huntley's third piece of advice, it's now all about the how. How are you going to transition to low carbon? How are you going to identify your strategic risks? How are you going to embed and capacity build, which is the hard bit, to make it real? And how are you going to have the right governance structures and assurance measures and culture to ensure that you can create that systemic change? And that's more of the hard bit, isn't it?
Yeah, it's the massive task ahead of us. We're almost out of time, but Luke, did you want to just briefly respond on that point?
No, that's okay. I think Rose covered it. Yeah, it's all good.
Well, other than to say it's the human rights issue that we're facing, for our next decade. There is no bigger issue than climate. One question that Margaret posed in the chat, and thank you for your involvement in the report, Margaret Stewart, was, has anyone done any work to not just assess and compare reports, but more to the point, determine what business have learned from the process, having done it, and how we might move on from that? Well, thank you for asking, Margaret. I'm actually part of a large team that is doing exactly that in a project with Melbourne, RMIT, UWA and UTS, along with 4 NGOs, the Human Rights Law Centre, Uniting Church, Baptist Aid and the Business and Human Rights Resource Centre, who are looking at exactly that question over the next sort of year and a half, looking at not only what we've done, but how we translate it into action and what needs to happen next to move sort of beyond reporting and the lessons learned. So hopefully we'll have another talk less than a year from now where we can learn pass on some of those lessons. I really want to thank you all for joining us today, but particularly I'd like to thank Ro Coronius, Luke Fletcher, Rachel Davis and Phoebe Wynne-Pope for their report. Thank the Human Rights Commission for joining with us on this really important work, in particular my co-authors Lauren Zanetti and Sarah McGrath, and really encourage you to read the report. You'll find it on both of our websites, and continue to engage with us in this discussion. Thank you so much for joining us today.